We have a very exciting guest on today. His name is Charlie Jamieson. He's an attorney from Florida who's been practicing for more than 40 years. And one of his specialties is dealing with people who have been falsely accused of all kinds of things, but especially dealing with people whose exes have tried to turn their kids against them for either, and they don't follow parenting plans. They may make false allegations about what that other parent has done to the child to not allow them to have contact. Oh, okay. I'm just looking, sorry, to make sure that he can get on. But again, it's attorney Charles Jamieson. He's from Florida. And we're going to be talking a lot about the term parental alienation, which is also known as abuse by proxy, or a form of coercive control where someone tries to turn the kids against the other parent, false allegations, how people are blindsided, when to litigate when your ex, here he is, when your ex starts blocking contact and communications. And Charles, let's see. All right, he should be on camera. Yeah. A lot of people are going through this. I read somewhere that 20 million people throughout the world are going through something like this. All right, so we got you on. I'm really glad. So I said today we're going to be talking about litigation and parental alienation, and what we also called abuse by proxy. But how long have you been practicing, Charles? And can you just introduce yourself?
I'm Charlie Jamieson. I'm board certified marital and family law attorney in Florida. I've been practicing law for approximately 40 years. Part of my career has been flying around the country representing individuals who've been falsely accused of abuse in criminal, family law cases, and in juvenile cases. And in that context, I've done a lot of work with parental alienation.
Okay, and you said that often cases like this, parental alienation and false allegations go hand in hand. Why is that?
Well, if you look at the concept of parental alienation, which is basically a demonization or vilification of one parent by the other, such that it destroys the relationship of positive bonds between the targeted parent and the child. In that context, suggestive questioning goes on, allegations against the parent goes on, the child finds it's easiest to not to resist those, but in fact just to go along because it's part of the parental alienation issue. Particularly when you're younger children. Younger children, you live in a land of giants, which are your parents. And whatever parent you perceive as being the powerful one, the one with the power, then that's the one you're going to rely with, ordinarily. Compound that with a divorce, compounded by also a potential personality disorder parent, or a parent with a highly active negative personality trait, then you're off to the races. They're both going to be hands in hands. If you have parental alienation going on, you will soon see at the most inopportune time in your custody case an allegation of abuse.
Yeah, and something you said really stands out, because that's a question a lot of people in our community ask, is like, if I've been the healthy, protective parent, why is my child going more towards the abusive parent? And what you said about how kids recognize, I think it's not just kids, but adults recognize who has power and they will align with that person.
That is correct. And also you have to take into hand in hand with that the malleable or changeable nature of memory. Memory, we often believe, well, we erroneously believe that memory is like a videotape or like a digital tape. You take a tape, you put it in your memory, and it doesn't get distorted in any fashion. Memory is an active process subject to distortion and changing. And when you have someone who's demonizing a parent, vilifying the parent, making false allegations against the parent, it's easy for a child's memory to be changed in that regard. Even to the point where
Can you talk go ahead.
Even to the point where they sound credible when they're making the allegation.
What kinds of people demonize other parents? Because it's not a common thing. I mean, in our community, it's very, very common. But in normal divorce, this doesn't usually happen, right? Like, why would somebody do something like that, knowing that a child is half of each of you?
Well, there's one that has come to devalue you. Someone who likes living in chaos, someone who likes has an all or nothing attitude about you. You're either all good or all bad. And if you're all bad, then anything is justified. So we're not talking about the normal functioning human being usually. In most of these high conflicted, high contested custody or visitation cases, we find individuals having some kind of personality disorder, and the targeted parent has been going along with that pretty much during the marriage, and now has become the false victim of it during the divorce.
Yeah. What about false allegations? You said that a lot of times, and we see it too, people are completely blindsided by false allegations. Can you talk about that and why false allegations are so harmful?
Well, first of all, you're blindsided because they will generally occur at the most, what I call the most inopportune time during your case. It will either be right at the beginning of the case, before you even get geared up, or before you even realize you have a custody case going on, or custody fight going on, or it'll happen just at the point in time when you think you're making inroads or gains in your case. I mean, I've had cases where I've turned to my client one day and said, although I can't guarantee the result, it's looking good for us. And the next day we walk into court and we're facing a child abuse allegation because the other spouse sensed that they were losing, and as a result of that, tried to take preemptive action. And of course, what happens is it shuts the custody case down. The court now has to come to some decision about did abuse occur here or not.
Yeah. Another thing is, so the false allegations we see also happen at the very beginning of a situation where people are like, how could somebody put that stuff on paper? Like, I never did anything like that.
Well,
right? That's what.
Again, what they're falling into the trap of. I've lived an honorable life. I've been a great guy or great gal. People believe me. They've taken my word for everything else in my life. And then they say I didn't do it. They're shocked and appalled that no one believes them because the system takes what I call axiomatic or stereotypical positions, which is one is even people who are accused of abuse who've abused their child say they didn't do it. So therefore, your denial means nothing to us. So you're forced in the position, you're shocked, you're forced in the position of trying to prove that something didn't happen. Rules of logic tell us that's impossible. So you have to come up with a case that demonstrates that this didn't happen. You've got judges who want to protect themselves as well as protect children because they don't want to let someone off of an abuse charge and have them turn around later and find out that the child was abused or some other child was abused. So they need to be convinced of the negative. So you're really looking at an expensive, time-consuming proposition.
You had said that one of the biggest problems in situations like these are professionals who are not trained properly. Can you talk a little bit about that?
Well, one of the problems that they have is the difference between a clinical and a forensic profession. A clinical person, basically, particularly if you're dealing with mental health professionals, are basically accepting what their patient says at face value. They're not going in to determine the baseline truth of that allegation. So when you have a child that says X, daddy did this to me or mommy did that to me, and that clinical individual is not going to do any kind of painstaking evaluation to determine the truth of that allegation. They are going to go along with it. Because they're not trained forensically, they're not trained in the issues of memory, and they may actually themselves be contributing or causing an iatrogenic escalation in the allegations because they are going along with the suggestible memory and further reinforcing it and making that changed memory become a permanent reality to that child. When we saw it as long ago as the 1980s in the McMartin case and the Jordan, Minnesota case, all dealing with inappropriate questioning techniques which caused false allegations or false memories to be implanted in the alleged child victim.
Okay. So you had talked about also that when someone is falsely accused, that the defense has to be a blitzkrieg. What's a blitzkrieg?
The blitzkrieg, at least in court, is you've got to get the experts lined up immediately. Start educating the court through your pleadings and through your hearings when you can get them as to what the reality is about these kinds of cases. And that, you have to have your experts who are familiar with parental alienation, familiar with what causes false allegations, familiar with the literature and the studies have been done on how memory changes over time and what are the pressures on children that may cause them to change their memory and make those changes permanent. You have to have someone who knows about enmeshment. You have to have someone who knows about parentalification. All these are complicated issues that judges don't frequently see because these are in the minority case, not the majority case. But if you're in the middle of one, you've got to come up with financial resources to get those experts because they've got many of the things many of the beliefs that have to counter or many of the facts they have to court to understand or come to believe is counterintuitive. In other words, everyone wants to think that memory doesn't change, that memory is in there and it's in there forever. That's a fallacy, but that's counterintuitive. We know that young children their memory can be permanently changed just by one inappropriate interview. We have people who are asserting that they have been trained in proper interviewing techniques when there's only been one interviewing technique that we know of that has withstood testing and study to show that it can come up with accurate results, or more accurate than any other type. So we know these things. We know that judges want to believe that both parents are going to be responsible for the alienation that has occurred, and that if there's smoke, there's fire. Well, sometimes if there's smoke, there is no fire, or there's the wrong kind of fire. So all these things you have to combat, and you have to have the financial resources to do that, and you have to have the emotional resources to understand that you are now in a marathon. It's a blitzkrieg, but it's still a marathon. You have to get the momentum going on your behalf to overcome these false allegations. Sometimes your best bet financially is to have a forensic professional, mental health professional, who's a forensic expert in all those areas, and have a custody evaluation performed, or in Florida, a social evaluation, we call it, something that looks carefully at the allegations, carefully at all the influences, does careful psychological evaluations. That takes time. But if you can get that in place, you have your best shot of trying to have truth prevail in these circumstances.
Yeah, you had used the line that family court is a battle of imagery, right?
There are two battles.
That's what you're talking about.
That go on. Yeah, absolutely. There's two battles that go on in the courtroom. One is a battle of fact, because that's the one we're all taught about, which is the truth will prevail. I don't know how many times I've heard that. Well, the truth doesn't always prevail. And the reason is that why the truth doesn't always prevail is because there's a battle of imagery going on at the same time. And what attorneys are doing or attempting to do is have you look like someone who might abuse your children. Have you fallen into the trap of so strongly opposing or vocalizing your innocence that it just starts sounding like you're guilty, or that the judge stops listening to you, or gets you to react inappropriately in your communications with the accusing spouse. So you need financial resources, you need emotional resources, and most people need some coaching along the way, whether it's by a mental health professional or by someone like your team who puts together a set of criteria of expertise in certain areas and experience that can assist people in responding to those kinds of issues.
Yeah, and I'm so glad you mentioned that about people like needing the financial as well as emotional resources, because this has a tremendous impact on people's lives, and it can become all consuming, and it's like everyone you turn to, you want to tell your story to, and it does make you almost look guiltier when you're so angry all the time. And so it is important to realize how you're presenting to other people, especially people involved with the case. And it's so unfair when these things get traction and just keep going. And I know in our shared community, people are like, how can this be happening?
Well, remember Alec Baldwin and his big custody snafu a few years ago, where they had an audio tape of him chewing out his daughter in the most vile way, because he didn't have any coaching. He let his anger overcome him, and he picked up the phone impulsively. He did not have anyone to turn to, or he was so impulsive that he rejected the help that he potentially had there to assist him. But that's what you have to avoid. That's a deadly bolt of anti-win when you do something like Alec Baldwin did, because people are going to be remembering that imagery forever. No matter what you say, no matter what you do to the contrary later, that's the thing that will stick in their mind, and that's the thing that's going to stick in the judge's mind. And the expert in trying to provoke you in that way is a disordered spouse, because they like to live in chaos, and they will make, and if then they're quick to demonize you, and because for some strange reason they seem to be very charismatic and able to present very well for short periods of time, such as you find in the courtroom. That is why a custody evaluation or social evaluation is so necessary, because that professional can break down the behaviors and look at the proof that you have to counter the allegation or the statements made by the opposing side, the alienating parent, as to how you allegedly act or did not act. With a judge, you're never going to get the time sufficient for a judge to be able to do that kind of careful analysis. So again, there's ways to approach these kind of cases that you can make you a winner, or they can lessen the blow. But you've got to be able to, one, understand the importance of it, and two, institute it.
Yeah. Now, we see all the time where people push the boundaries with honoring a parenting schedule, a parenting agreement. When should someone actually start to litigate? Often, not just the parenting schedule, but when someone, their kid comes back to them and says, "Mommy or Daddy is saying these terrible things about you," and you can see it happening, the turning against one parent. But what's the tipping point? When should someone go back to court? Because we always say you don't want to go back without having like strong evidence for a case.
Well, okay. Tipping point will vary from case to case and from analysis to analysis. The tipping point comes when they start vocalizing they don't want to start, they want to be there, or they're expressing reluctance to be with you. Because more and more we're seeing cases where 50-50 timesharing is put into effect. In Florida recently, there was a statute passed that makes that the presumptive starting place for every judge in decision making. If you have 50-50 timesharing, or you're utilizing every bit of timesharing that you have with your kids, then you're providing the best opportunity for you, the least expensive opportunity for you to defeat these allegations or defeat the alienating process, because your children are getting the opportunity to see just who you are in reality versus the image that's being painted about you at the alienating parent's home. So that's but if when they get to the point where they start expecting reluctance to be there, that's when you know you've got some problem. But before that time, you should be working with either coaches and or attorneys to try to say, what kind of evidence do I have to put together so that if and when that time comes, I have the evidence necessary to interest the court. Because the court's going to be quick to think, oh, we got the typical squalling parents, they can't get along, behave yourselves. And that's one of the myths of parental alienation that you have to overcome if you're going to litigate, which is the judge's tendency to immediately think this is the fault of both parents rather than primarily the fault of one or the other.
Yeah. I was going to say, let's see, when you talked about when we first spoke, how contact with your child is the most important thing. You talked a little bit about that just now, but you also talked about having more eyes on your child. How can that help you as well?
In the world of false allegations of abuse, the more contact your child has with the world, the more likely, the more opportunity there is for that child, if he or she is a victim of child abuse, to blurt something out or to act in certain ways that would cause a concern of adult individuals dealing with the child. So the children who attend school, children or aftercare, children who play sports, have coaches, children who take musical instruments or do activities that require instruction. The more contact your child has with the real world, the less likely, I argue, that abuse is likely to occur, because where's the bleed out? If my guy or my gal is as bad as they claim they are as a parent or abusive parent, and because some of these allegations are horrific, then where's the bleed out on the child? And also, I say, how does this parent, if they're as bad as you claim they are, as impulsive as they are, cannot keep control of their obsessive compulsion? Where's the bleed out in the real world if they're taking their child to these events and being with the child, and the child's acting in an ordinary, loving way towards them? Now, everyone would be quick to say, well, the abuse could still be occurring, yes, but we're dealing with probabilities here and likelihood. And let me just make this point. Between courts, if you're in criminal court, you're in proof beyond a reasonable doubt, which is if you have this balance of scales, you got to tip the scale substantially in the state's favor in order to win. In family court, the burden of proof is preponderance of the evidence, which is an ever so slight tipping of the scale, marginally in one favor or the other. Because of that slight tipping difference with the preponderance of the evidence, it makes it more difficult for you to prevail. Why? Because judges have less leeway in order to make an error. What I mean by making an error, by making the wrong decision. It's easier for them to say abuse happened than not. When there's a beyond a reasonable doubt standard, much more difficult.
Yeah. You got a question. What about when dad has the children manipulated into thinking that I'm a bad person, and all the eyes that are on the kids already believe that as well? So we see that a lot, where it's almost like a smear campaign. So that person, the abusive parent, has already laid the foundation with the community that that person is bad. How do you
Well,
handle something like that? I know this is outside of court.
well, again, if you look at what the typical parental alienation allegation is, it's a set of what I call the bookend. One end of the bookend is you had a great relationship with the child, and there's evidence of that, and no one can deny it. Then at the end, there's the allegations that say your child doesn't want to have anything to do with you for whatever reason. In the middle is what was the reason, and if there is no objective reason, then that's alienation. If the parent, however, has been an abusive or neglectful individual around the child, either to the other parent or to the child themselves, or been in improper parenting, engaged in improper parenting behaviors or dysfunctional parenting behaviors, then that may be justified estrangement. But then that's why I say you sort of you got to have an expert look at these things to know these things, to be able to present them to the judge appropriately. So you go to the historical record, say this is good, it's bad now. They may say you're a schmuck, but we can say that's the result of good campaigning. But my question always is, when I hear that, is there's got to be someone out there that still says you're a good parent, or, because that's what the judge is going to think. How did you get from being a great parent to being a reputation of having a bad parent? Is it just a smear campaign, or are you doing things that you're not aware of that's creating a bad image of you? In other words, what's your contribution to that? Which is again why coaching, but even if you can't afford an attorney, you may be able to afford a coach. You may be able to come in and say, "Tell me what is it, what?" Because, and then sometimes you can have a guy who's a parent who's engaging in estrangement, but parental alienation is overwhelming everything. You can have fleas and lice in the same dog. They're not mutually exclusive. The question is what's what percentage do we have of what issue?
Yeah. And I'm so glad you noted that, like the bookends and like what's the reason how you were a good parent and now they want nothing to do with you. Like what happened in between?
Right.
How can someone gather evidence, let's say documentation, in a situation like that for the reason? Like what are some good things that they could use as evidence to support their case? I mean, I have some ideas, but I just want to hear what you have to say.
If the communication with the alienating parent will probably provide you some input. In other words, she's going to say, well, the kids are saying X about you, or no one likes you, or you do X, Y, and Z. Or I was talking to Carol and Sue, and they hate your guts too. And you may never had any dealings with Carol or Sue, or you don't understand why Carol and Sue are doing this. But again, there's going to be some kind of trap, because one thing that the disordered parent cannot help themselves is go after you. They think they're all good, they think you're all bad. So there's going to be something in writing there. If they turn your family, if you're saying to me that your family members don't think you're a good parent, then I'm going to want to talk to them, because blood going against blood is a bad thing.
Yeah.
Judges never take kindly to that.
Yeah, and that's really tricky, because we see that fairly regularly in our community, where an abusive parent has aligned, and they do it over time from a while ago with the targeted parent's family.
And again, that's why it's so important to say what to create the structured analysis of parental alienation, and not get up. But again, those cases, they happen, and I'm always concerned about them, but I want the full facts, even to the point where I may take the deposition or the interview of the people who don't like it. And if they say that people don't like me, I say, well, find other people.
Yeah.
There's nothing that prevents you from having a get together at your house when your kids are there with some people and their kids of similar ages. You can create your own witnesses as to how your kids interact with you.
Yeah.
So
Great point.
So don't be in a situation where I have no allies; they're all enemies, because you can always create other allies. If you're a good dad, if you're really a good dad or a good mom, and your kids are not completely alienated against you at this juncture, that's something you can do. Get them involved in activities. One thing I always talk about is the hook. The hook is what activities can you do, or things you can get your child interested in that the spouse will not. ever do. Here's an example. This comes from one of my cases long ago in New England. My client was a very involved dad. The mother was alienating the hell out of the kids. They were claiming they were young girls claiming they didn't want to have anything to do with dad. So one day dad had visitation with them and stopped at a feed store. Why he stopped at a feed store, I don't know, but he did. And they were in springtime, they were selling ducklings. He bought 2 ducklings, brought them home, and the kids fell in love with them. So he built a duck palace, I called it, in the backyard.
A duck palace?
Duck palace in the backyard. And the kids were constantly campaigning Mom to go see the ducks. Mom would not have any ducks in her house, couldn't have any ducks. She was living in a condo. So that was a hook. It was something that is special that your young kids can do with you. Now, in today's world, there are web games or web-based games that you can play with your kids. There are other books you can get, 101 Ways to Be a Great Long-Distance Dad and Mom Too is a great starting text, even though they're written for parents who are a distance away from one another, from their children. It is one that gives age-appropriate techniques to communicate with your children that are kind of interesting and neat and out of the ordinary.
What? Say it again. 101 ways to be a great long
distance dad or mom too. That's not the exact title, but it'll get you there.
Okay, I'll find it. All right. So another question. This is a good one because this we see a lot. So someone said, after all the alienation, I was suffering mentally, so I took a brief step away where I just stayed away, and now the courts are looking at me negatively for not filing in a timely response. But I'm thinking also of, in general, parents who their kids are turned against them. They say, you know what, I'm just going to give them space, so I'm not going to have contact.
That's a bad thing all the way around.
Okay.
Although,
tell us why.
It's bad because of one, what you've just told us is that it gives the court an out. Court is an out, says that you didn't have contact with your kids, you didn't express interest in your kids. What are you doing? What are you doing now? The second thing is, if there's anything that we know longitudinally in these kinds of cases, is that you cannot give up contact. No matter if it's just reaching out, even if it's just sending a letter, even if the letters are sent back, even if you suspect that the alienating spouse or ex-spouse is destroying them or preventing the kid from having them, make copies of them. Take photographs of the gifts you sent. Someday there's going to be some kind of meeting. Inevitably, in these cases, there is. And you have to have at least some proof of what you've done. You also have to show proof to the court that you haven't given up, that you are involved. Because inevitably, they're going to say you don't care, and it's one of their allegations, and the fact you didn't care is the reason why you didn't have any contact. You didn't write to them. You didn't send postcards to them. You didn't send them presents, blah, blah, blah. It is tough for parents to hear this because they are in despair. They think that they see no good result at the end of this, but don't give up. I've had cases where the kids were so alienated, they were claiming their father was taking them and punching them against plaster walls and leaving dents in the plaster. Obviously, it didn't happen. But within 3 years, all those kids were living with their dad. So, again, not every case is going to end up that way, but when I see examples of what can happen, he never gave up. He kept sending letters, kept sending communication, written communication. And the kids, and telling one of his sons said, Dad, sometimes you have to do things you don't want to do. Just to survive.
Yep. Same thing we tell our kids too.
Yeah.
Right. So also in our community, that a lot of our clients have supervised visitations, often because of false allegations, while the court is, doing analyses and evaluations, and they feel like it's a punishment. You said that your impression of supervised visitation changed over time. Can you talk about that?
When I was a young attorney, I was outraged that anyone would suggest my innocent client should have to have supervised visitation, and that we were making some kind of admission of wrongdoing when we would agree to that. When I came to I did change, and I have changed that opinion over time. I believe that under the proper case and circumstances, that you can use that to your advantage. if in fact you have a good relationship with your kids, in fact you have good parenting skills, then that gives you the opportunity to show it in front of a neutral person. Because the supervisor's got to be neutral. It can't be someone that they select or someone that you select. And then if you have someone who comes and makes the statements to the court about how you are parenting, how the kids are really reacting to you, and that they see nothing wrong with your parenting, or they see the child acting normally towards you, then that rebuts all the allegations that the alienating spouse is making, or the falsely accusing spouse is making, in terms of the kids not wanting to see you, in terms of the kids being damaged by you, and on and on. And also what happens sometimes, and when you're really dealing with disordered parents, they're going to start showing up at these exchanges with the supervisor they're acting out. And I mean, when that happens, that's gold. And so I've come to believe that the cost is well worth it, that more ways than one, it's going to be helpful to you. And it's going to create, especially for clients that say everyone says I'm a bad parent, gives you another opportunity to create a witness for you. And it's one that the judge is going to look at very carefully, because this one person has no dog in the fight.
Yeah, and so also when you're talking about supervised visitation, like you said, it's with a professional. So you would also recommend not having a friend or family member do it, even when it's more expensive, because then you can't really use them as a witness, right? Or not as strong as a witness.
Well, they're already biased, and sometimes
Right.
because they are family members or friends. But I mean, you have to do what you can afford. I mean, I would rather have someone there than no one.
Yeah, yeah. All right. So any other tips for people who are being falsely accused of all kinds of horrific abuse and their kids are being turned against them? You said probably the most important thing is to still have contact with your kids, right?
Whatever contact the court provides you when there's allegations of abuse, that may be limited, but it may not be cut off completely. Be aware of, your spouse trying to agitate you before the phone call or during the video conferencing or whatever it is, or denying you or trying to get you pumped up with anger, because they're just going to try to provoke you to an outburst, which is not, again, we're going to the battle of imagery here. It's not going to serve you well.
Yeah. And then quick last little question. So often when there's everything we talked about, how things are delayed, and that actually works in an abuser's favor because the delays keep you from contact with your kids. While someone's waiting for a hearing, is there any way they can get visitation in the meantime?
Well, you can ask for visitation, but again, it's going to take a hearing. And the question is what evidence do you have that's going to cut against the concern of the judge based upon what evidence was presented that caused the injunction or order preventing contact from occurring. Generally, these are sometimes even ex parte hearings. They get the initial injunction. You may be entitled to an expedited hearing for contact. They will examine the facts that are being asserted. But again, what that will do is give you a better sense of what's going on in the case in terms of who's making what allegation. But it's not going to, may not get you a whole lot of remedy. So your best shot in may be first trying to get supervised contact, and at the same time get a custody evaluation and or social evaluation going on to get a forensic evaluation completed regarding the allegations.
Yeah, so this is making me think of when someone, let's say a judge makes an order and says, okay, you have to honor the parenting time after someone has not been sending their child to the other parent, and then the hearing isn't for several months or a year, and then that parent still refuses contact, and it's like they already broke the law and now they're still breaking it, and you're waiting for a hearing. Nothing you can do in the meantime because you still just have to wait, even though they're still continuing the behavior that got you to the first hearing?
Well, you can always ask for an emergency hearing. Unfortunately, emergency hearing is what I call blood in the streets. I mean, unless the child's in an extreme, you have objective evidence of extreme physical harm or the child's safety is in danger, you're not going to get much emergency relief. You might want to ask for an urgent hearing or a case management conference so that the court's aware of your concerns and try to address hearing that way. But again, the courtrooms are becoming more and more congested. Judges are being inundated by more and more cases, even though they want to say that the divorce rate's gone down. Once you have a divorce, you have enforcement actions, modification actions. So that doesn't mean the case is one and done. So they have thousands of cases they're dealing with. They don't have the time to deal with it. They don't have the resources. So the processing cases are going slower. The slower the processing of the case, and the more quickly you must get involved some kind of forensic evaluation. And that's just the only way you're going to get light at the end of the tunnel. But
yeah, there was a follow. Go ahead.
The danger of that is that the children may say, I don't want to have any contact with you. Their alienation may be further advanced along the way. So then you're facing the circumstances of how are the judges willing to pull the trigger on an extreme treatment program. An extreme being a removal from the alienating parent for a period of 90 days or so, and a specialized treatment program that will do a deep dive into the relationship and reunification of the parent with the children.
Right, but you were saying before when we talked that that's not a common thing. A lot of judges are very hesitant to do those.
Judges will be very hesitant, but again, my concern is when you only have 168 hours in a week, and you have 1 hour of therapy, how's that going to undo all the alienation that's going on? So, you may be getting a remedy which does not provide you relief.
Yeah, yeah. All right. Well, Charlie, thank you. So actually, let me ask this last little thing. So when you talked about like blood in the streets, like is 2 years of failing grades enough to go back to get an emergency hearing?
Well, you're not probably going to get an emergency hearing, depending upon what your jurisdiction defines as an emergency. My jurisdiction would say that's not enough. It may get you an urgent hearing. It may cause the judge to perk up and say they may deny the emergency hearing, but they may grant you a hearing quicker. Or you can ask quickly for what's called a case management conference, which is the court says, what are the issues pending before us? And you can request expedited scheduling on the basis that these are important issues.
All right, that's really helpful. So, Charlie, thank you so much for your time. And I know there's a million things we could keep talking about, but I don't want to. I don't want to keep going for now and let you have lunch. Can you tell people how to find you?
Yes, you reach us by phone at 561-478-0312 or at our website www.cjamiesonlaw.com.
Okay, and what state again? Just remind people.
I'm in Florida, but we do consultations around the country.
Okay, great. All right, well, thank you so much. This is really helpful. I took lots of notes.
It's been a great pleasure. I hope my best of luck to you and to your clients.
Yes, thanks again. Talk to you later. Bye.
Bye-bye.